program. And Rubaiyat, you ready? So today we are very fortunate to have Rubaiyat Mashrak. He has a lot of good qualifications, but I will defer that to somebody else talk about. So he's going to talk about patent and all of things. And what can be better than when your better half talks better things about you. So that's our situation is. Shurovi is going to give an introduction to her husband, Rubaiyat. Go ahead.
Assalamu alaikum. Assalamu alaikum, everybody. So I'm going to introduce my husband, Rubaiyat Mashrak. He has a bachelor's in science and engineering from Buet in 2000. Rubaiyat worked as R&D engineer at Optical Network Division of Agilent Technologies in Germany. He received his Doctor of Jurisdiction degree from the University of Victoria Law School in British Columbia, Canada in 2006. Rubaiyat practices intellectual property law with exclusive focus on patent law. He's a member of the State Bar of New York. He's admitted to the U.S. Court of Appeals for the Federal Circuit, First Circuit, Second Circuit, and Third Circuit. He's also registered with the U.S. Patent and Trademark Office as a U.S. patent attorney. Rubaiyat drafts, files, and prosecutes patent applications for university faculty, corporations, and individuals. He focuses on electrical and computer engineering, computer science, mechanical and medical patents, and also prosecutes patents covering other technologies. Rubaiyat and I, we live with our family here in Long Island, New York. I am also his assistant, and I'm a pharmacist by profession. So I'm just going to hand it over to him right now and just let him take over. Thank you.
Right, so thanks a lot to Suravi for the kind introduction, and thanks a lot to Anis who kindly organized this event to actually let me talk about this particular topic. So what I'll do, I'll start sharing my screen and the presentation that I have. So let me share my screen. Please let me know if you don't see the screen or the presentation. So if everybody sees it, so I'll go ahead with it. So
yeah, go ahead.
Okay. আচ্ছা আমি কি বাংলায় বলবো না ইংরেজিতে বলবো?
You can
go ahead in English. English is better.
English is better. আচ্ছা ঠিক আছে. So I'll give the whole talk in English from the beginning. So what I'm going to talk about, mainly about patent, but with the perspective of how to build your business based on patents, because patents give you a lot of rights and legal rights that actually helps you build a concrete foundation for the business. I'm going to go to that a little bit more. That will be different tips that I'm going to be talking about, mainly 7 tips. I'm going to go through them 1 to 7 in that order. So let me go through a little bit more. So we already talked about it. The reason I wanted to give this slide is I'm mainly focusing on computer and electrical engineering, computer science, some mechanical engineering, and some electrical engineering patterns, because I did my bachelor's in computer science and engineering from Buet. We had all these courses, so I have that background. These things, my core admissions, you already heard about it, so I'm not going to go through them. So this is what I'm going to talk about. So a lot of us wants to, particularly in Bangladeshi community, we are immigrants, we are kind of left our country to come to this foreign country to build a better future. So a lot of us want to build a business, want to be an entrepreneur, And the way we do it, we are sometimes in high technology field and other fields, we are actually building different types of business. Either we're selling products in Amazon, even if for that we are designing a product, or we are building something very high tech, like what Anisbhai does, builds a very high tech equipment and provides services and sells those products. So to build that kind of business, patent actually gives a very good protection. The reason is when you have a patent on a particular technology or a product or a process or any way to manufacture a product, that gives you about 20 years of monopoly. So you can exclude any of your competitors from building that product or selling that product or even importing that product into the country where you have the patent. Let's say you have a patent in US. So you can exclude anybody from the entire world to sell that product, market that product, or import that product in US. Patent is actually jurisdictional. So if you want to do the same thing in Europe, you need to have a European patent, but I'm gonna come to that later. But what I wanted to emphasize was this, if you have a patent on a product or process, you can exclude any competitor. Let me go to my next slide. So this is the main first tip. So you want to protect your idea with a patent. Why? Because if you have a business, you can protect that business from a number of perspectives. You can build a good corporation infrastructure. You can build a partnership or a limited liability partnership or limited liability corporation, SCorp, SCorp. There's all those kinds of structures that gives you benefits in terms of tax law. So some of those lets you reduce the tax, how much tax you're going to pay for it. And also if you are a corporation or a limited liability partnership, you can limit a lot of liabilities and a lot of liabilities from creditor, from lawsuits and all those perspectives. So that's one kind of protection or one kind of basis on which you can build a business. Other things you can typically do, and typically everybody does that, is you can file for a trademark. For example, on this slide, I have put a lot of trademarks that everybody knows about. So whenever we look at this trademark of Tesla, we immediately get a feeling of what kind of quality of car that will be. Same thing with Ford, same thing with GE, or same thing with Intel. We know when I buy a computer, whether it has an Intel logo or AMD logo, that makes a lot of difference. Or whether there's a graphics card, whether we just want an Intel graphics card or an NVIDIA graphics card. You get the point, right? So the basic idea is with your trademark, your business is totally linked in a way. So the quality of the product, quality of the service, but it's still, it doesn't actually stop a competitor from starting the same business. So even though Tesla has this trademark and everybody knows the quality, it's not, cannot stop anybody else from starting the same electric car product. The same product with the same qualities and the same appeal and everything. So anybody can actually, even if you have the trademark, anybody can make the same product under a different trademark. So nobody is stopping a competitor from doing so. Same thing for the corporate structure that I was talking about. Nobody is stopping, corporate structure is not going to stop your competitors or anybody else from taking your market share. You can, if you have an idea, you can also try to protect that idea using a trade secret. For example, like everybody knows about famous Coca-Cola trade secret, how the Coca-Cola, that content of the drink is a trade secret. So they kept it under the secret. But the problem is, as soon as somebody finds that secret or develops that product by themselves, nobody can also stop that company or that competitor from producing that product. So this is where actually patent comes in. because patent can actually give you a much better protection, particularly for your business, to stop the competitors from building the same product. So for about 20 years, you get absolute monopoly. So if you want to protect your idea, the recommendation I'm trying to propose here is you should think of patent as one of the most important way, particularly if you have a product or if you have some kind of high-tech process or some sort of manufacturing process, then patent is a way you can actually get a complete protection from any competitors for at least 20 years. So that is my first tip. I'm going to move to the second one, which emphasizes the point that the patent, why patent is important and what this about 20-year monopoly does. I'm saying about 20-year here because the term of the patent is determined from the date when the patent is filed or the earliest filing date for the priority date of the other applications. And it actually is effective when the actually patent gets granted, which is typically happens around 2 years. So, from the filing date, you get 20 years, but your patent is granted after about 2 years. So you get about 18 years of protection. It's pretty good. It's not totally 20 years, but it's still pretty good. So in this slide, I have put some of the famous patent cases. Many of you might have read in newspapers or online or media. One of the most famous recent cases has been Samsung versus Apple. And as you know, it is a case between Samsung's cell phone, their Galaxy cell phones, and Apple's iPhones. And the core of that patent case is some of these patents that I have outlined here. So that deals with icons on the iPhone and the home button of the iPhone, and even the rounded corner that you can see in the old iPhone, even the new iPhones have it. You have the rounded corner around all 4 corners. So those were all protected by not just utility patents, but also by design patents. So how the look and feel of the iPhone and something. So you might think a icon or a home button and design of a product might be a simple thing, but if you have patents like what iPhone had or Apple had, you can even have these kind of multi-million-dollar cases where Samsung was ordered to pay hundreds of million dollars to Apple. I have listed some other products or cases here too. It covers pharmaceutical industry, it covers IC industry, chip integrated circuit industry, hard disk, electrical engineering, computer engineering, you name it. It can cover, I mean, patent cases have been fought for many technologies, and each of those cases can cover hundreds of million dollars. That might be for the very high-tech companies, but even for a small company, it could be in the range of millions of dollars. Why it's so much is because for patent infringement, each infringement product that is being sold is considered one count of infringement. So for each of those count, the defendant actually has to pay damages. That's why for Samsung, you see the damages so high because Samsung sells so many products. But even if you're a small company, if you're selling, let's say, thousands of products, and per product, let's say you have a damage of $100, even $50, it could amount to a significant amount of money. So that's why I'm saying, I'm emphasizing that patent is very important, and it can actually give quite a bit of leverage on top of your competitor to build a business on top of it. So I can go ahead with other tips, but while I'm at it, just wondering if any of you have any questions.
Yes, I do, Rubaiyat. This is Saifur Rahman,
Yes.
Virginia Tech. I'm a professor of electrical engineering. So you mentioned previous slide, LLC and SCorp, right here. So I have a startup company. I did LLC to begin with. Then I was told to move to SCorp. That's advice given by accountant. It's not a single member SCorp. So the name still LLC, name doesn't change. So is that the right thing to do? I should have done SCorp. That's my question. SCorp over SCorp.
I mean, SCorp and SCorp both has a couple of, with SCorp for a small corporation, it's simpler because then you are taxed by, you're taxed as a pass-through. So you're taxed as like individual, while you are actually expensing all your expenses and everything for the corporation. But in total, the pass-through money that comes in, you are mingling with your other income and you're paying the whole thing as a sort of like a kind of like an individual tax. But with SCorp, it's a little bit separate. So you have to file a taxation for the corporation, and etc. So if you have a small corporation, not such a big operation where you have lots of things going on, I think SCorp might be a good way to go. So he might have been accurate. But although I don't practice in that area, but that's what I think or my opinion is.
Thank you. That helps. Thank you.
I think I can add a little bit here. If you are losing money on your LLC, then SCorp is better because you can write off during your tax filing, personal tax filing.
Right.
If you are making money, then it is SCorp is better because there is no tax benefit being as an SCorp in that situation.
Okay, that helps. I'm not making money yet, so I don't fit. Thank you.
Go ahead, Rubaiyat.
Okay, so if no questions on this slide, so I'll move on to the next one. So this is the third tip, and this says what kind of ideas can actually be patented. To begin with, not all of the ideas are actually patentable. So there are only 4 types of ideas that US Patent Office permits to patent. One could be a machine, so any kind of machine. It could be a device, it could be an IC, it could be a mechanical machine or anything like that. Or it could be, second type is a process. So the process could be making a particular chemical compound, or making a manufacturing, making a kind of combination of combining different things to make a mechanical product, or any kind of other processes. A lot of the things like in computer world, like in algorithms, or I mean, abstract algorithms are not patentable, but many of the computer processes are essentially steps or methods or processes. You can say there are a couple of steps that you have to follow in that computer process. Then you get something. Either it's a encryption or some sort of data storage or some sort of other things. So those can be a process. Manufacture is essentially a way of saying similar kind of process that produces a manufactured item. Let's say a manufacturing process of producing sliced bread or any kind of device or toy, or any kind of, let's say, manufacturing process of making an IC. So that could also be a manufacturer. The fourth type is a composition, which is essentially a composition of matter. Those are mainly for organic or inorganic chemical compounds, or more importantly for pharmaceutical industry, it's for making different kind of drugs. So it kind of says, okay, you mix this and mix that, and then you get a kind of drug or something that can have some medical properties. So those are the only 4 types of ideas that are patentable, but not an abstract idea. So if there is a, for example, mainly if you look at physics or chemistry or biology, particularly in physics, there's a lot of abstract ideas like E equals mc squared, or any kind of formula that actually, it's just something that happens in the nature. Somebody found out, some scientists discovered it, but it's an abstract idea in a sense that it's not related to any of those 4 things. Like it's not related to a machine, it's not related to a composition of matter, it's not related to anything concrete. So in that case, that's also not patentable. I have put a kind of like a flow chart on the right-hand side to actually describe this kind of test or a process to figure out if your idea is patentable or not. So the first thing is to figure out whether it's a process, machine, composition of matter, or a manufacturer. If it's not patentable. Now, it also has to be not an abstract idea and so forth. So that's what this process or flow diagram actually talks about. So if you have any questions on this process or flow diagram, then I can answer that if you want.
I have a question. My name is Mohammed Farouk, the chemical engineer by profession. The composition patent, but composition, same composition, if for different, completely different uses, can each use be patented? Like Gore-Tex, you know, uses.
The patent law says if it's the same composition, even if you discovered a new property or new usage, it's not patentable, unfortunately. So there has been a few cases where it has been tried to patent a already found composition or a compound. So particularly in the pharmaceutical industry, somebody came out and said, okay, I found a new usage of that drug, which is a composition of matters, and it can cure this disease. Court came back and said, no, you can't patent it because it's already been patented or invented or publicly disclosed. So unfortunately, that's not possible.
Okay.
May I ask you a question, Mr. Marshall? Yeah, my name is Tohidul Alam. I'm an electrical engineer. So since 2019, after this new patent eligibility guideline was published, what is the normal trend? I mean, I guess my question is, like, when you receive a rejection under 101, right? 35 years to 101, right? And obviously you have to respond by saying, my abstract idea is integrated into practical application, right? Or then you have to go to the next step where you say, well, the invention as a whole is beyond, is an inventive concept. So what I want to know is that where do you guys find it is easier to respond, whether it is integrating into a practical application part, or just looking at the whole claim and say that the whole thing as a whole is an inventive concept?
I mean, arguing the whole thing is an inventive concept is a little bit, how do I put it? It's a little bit perspective based, but if you can argue that it has additional elements attached to it, that's a more concrete and more detailed argument. So you can go through step by step and can say, okay, in this step of the, let's say in many cases, computer algorithm or computer process related ones get rejected in this way. Business methods are already thrown out of the window, so those are all, most of them are gone. But this computer process, there you can argue my process gets calculated inside a CPU. Without a CPU or a microprocessor, it cannot be calculated, because if somebody wants to calculate it mentally inside somebody's mind, it's not, due to the volume of the computation, it's not totally possible. Or you can say, my data has to be actually written into a large volume data storage device, which could be a hard disk, solid state device, or any kind of things. So here you can go through each of those different steps and step by step, and you can argue that this is not an abstract process because this cannot be done without these, for example, in terms of computers processes, cannot be done without this computer hardware or computer, concrete computer equipment. So that's much easier to argue than a total, in absolute sense, or as a whole, it is patentable.
So I have another part. So are you using, when you're responding to this thing, do you use Berkheimer? Like when patent office says, wow, this is well-known method, you are just applying it in a new field. So do you ask for, say, show me the evidence where, how do you know it? How do you know it is well-known? Have you had that situation?
I mean, by law, they have to, I mean, whenever patent agents, examiners reject something, they have to give as detailed as possible explanations, because that's kind of like a onus on them to make it easier for the respondent to respond. So they try to give as much explanation as possible, but then it's essentially, I mean, there's been a case laws that says if it's a, it took a lot of steps, it took a lot of research, it took a lot of, I mean, there have been market research and other things that can be done, but those are typically done in trial because you're not going to do a market research to respond to patent examiners letter, right? So essentially you tell them all those things that has been happened that is not obvious. Or you can also say, we spend this much time on researching this concept. So had it been obvious or had it been so easily found, then we could not have done that. You can argue.
I think I should mention for the benefit of our participants and speaker that among us, there are some patent examiners without naming their name. So, you know, yeah, you have to use discretion when you are answering questions. Go ahead, please.
I think it's okay. I think he can answer. It's okay. I think we cannot talk about any policy issues. I'm just Mr. Mashrak. I'm just asking this question from a customer service perspective. So
right,
it's
right.
just that any patent applicant and patent application is a customer of U.S. government. So what I guess the crux of my question was that, do you see it easier in 2020 than what it was in 2019? Is it getting better, like filing inventions and then office giving you rejections, hey, it's an abstract idea, it's not patentable? Is it better or worse?
I mean, I think it depends on the invention in a lot of cases and the examiner on a lot of cases. I mean, there's so many different types of inventions out there, so many units in the patent office itself that are dealing with it. And I mean, if you look at just even the statistics that are released by US Patent Office, different units have different kind of statistics in terms of rejection rate, in terms of all those rates. So it's kind of hard to say. I mean, from our perspective, it's a little bit harder to say because we don't have that many statistical data points as US Patent Office itself has. But even based on those massive or almost like a comprehensive data points, the statistics that Patent Office releases, even that's a little bit varies among different units. So it's kind of hard to say.
Thank you. Thank you for responding to my question.
So I'll go to the point number 4, where it's about non-provisional patent application. So there are 2 ways you can file a patent application. You can either file a provisional patent application or you can file a non-provisional application. So the difference between these 2 is provisional patent application will actually expire after 1 year. So you have to file a non-provisional application within that 1 year time frame if your application is not getting abandoned. So in many cases, a lot of the patent applicants actually want to prefer filing a provisional application because it takes less money. But in terms of filing it, it still takes a lot of effort because you have to make sure you are putting all the inventive concepts in there, because next time when you file a non-provisional application, you cannot add a new inventive concept, because in that case, the filing date benefit that you get from the filing the provisional application will not be gained if you file it, if that inventive concept is actually not included in the provisional patent application. So there are many cases where it's a provisional patent application can be filed or should be filed, because when somebody has an invention, they are working on it and they are not really sure, it's actually more preferable to do that, or they want to file it as soon as possible. But many people file a provisional application thinking it's a cheaper way to do it, but essentially that's not the case, because when you're filing a provisional application, you have to file a non-provisional next time also. So you have to pay all the filing fees for the non-provisional application and all the legal fees for the non-provisional application. So in the end, it becomes to be a little bit more expensive. So unless somebody is in a big hurry to get the patent, or they're trying to kind of do some fine tuning and do some research, it's actually, my recommendation is to just file the non-provisional, because it may take a few days more or a week more to file it, but you get a better route, or you don't have to worry about filing a non-provisional later, and you actually, in the end up spending less money. Is there any questions on this slide?
I have a question. The patent is to prevent others from using your idea, but at the same time, you patent to keep the rights yourself to use it if you need to use it commercially. Now the question is, sometime to save cost, is it a good idea to file provisional patent application and then don't follow through? That way you have documented the idea, and will it give you the rights to use it in the future if you need to? Because somebody else can come with the patent, because same thing. Can he come up to you?
It's the same idea as if you publish a research paper, then it's open to the public, so nobody can later come in and file a patent application on that publicly available information.
But so you are giving out the idea. If you publish it, you are giving away the idea, but you can hide it by maybe the other technique, which I myself in my professional career, I followed a lot. So, I'm just checking with you. What do you think?
Right, but with the provisional patent, unless you file a non-provisional application within 1 year, it's similar to almost publishing as a research paper, or publishing it in a journal or any other publication.
Excuse me, I was told that nobody really gets to it. It's never published. Nobody can access it. That's what the attorneys I consulted told me.
Yeah, that's the case. That only gets published after 1.5 years after you have followed through it. So you can actually, I think what you're getting at is if you want to use that prior art in your other next applications or something like that, but you are not completely disclosing it. Is that what you are asking?
No. My point is, I have an idea. I don't want to tell it to anybody. And I am taking chance by not patenting, saving costs. But if I have to use that in my product, I'll be still retains the right to use it because I have documented it through a provisional patent application.
Yes, definitely. Definitely. That's like a prior user rights, and you have
Right.
actually gone even beyond that because you're actually filing a patent application for that, provisional or non-provisional, whatever it is, without a publication request or something like that. But essentially, it's like if you are a prior user, you have an existing user's right, even if you don't file the patent application and later somebody comes in and files a patent application, as an existing user or a prior user rights, you still have the right to actually use that because you used it earlier.
But how do you establish that you are a user? Because you have an idea, you may not have used it. You just,
right.
By a provisional application, you documented that, yes, I had the idea and it was an usable idea.
Even if
That's
you don't
that is
file
the difference I see.
Don't file a provisional patent application, you can establish the fact that through email chain or through other electric document chain. Because nowadays everything, all the emails, if you go through electronic discovery process, anybody can pull in all your emails and say, okay, he mentioned this thing to this people, internal company email, internal other emails, where they actually discussed how this thing can actually be done.
That's a good thing. Yeah, that's a good idea. Yeah, thank you.
So nowadays you can do all those things with e-discovery. I mean, in old days, it would have been a little bit harder. Then you produce some sort of like lab notebook and other things, written documents. Then who knows when it was written, unless there was a established office process where all those documents are filed, maintained in that way. But nowadays with electric documentation, e-discovery, everything is a little bit lot easier than before. Okay, let me move on to next slide. So, so far we only talked about mainly utility patents, where it is actually provides some sort of functionality or some sort of utility of the product or the process. But even if the product does not have any utility or function, if it's a design, then you can also file a patent application for that design. You are not going to get 20 years of protection, but you are going to get 15 years of protection for that design patent. And that 15 years starts from the date you are actually granted that patent. So I have repeated one of the things that I put in earlier slide. It's about that Samsung and Apple patent dispute, or where you can see I highlighted some of the parts like icons, home screen button, and the rounded corner design of the iPhone. Those were not actually utility patents. Those patents in question were actually design patents. So whenever Apple actually releases a product, they cover a lot of the design aspect of that product with the design patents. Same way a lot of other companies also do. Like I have put some diagrams or drawings over here. You might easily recognize the Crocs shoe. That's a design patent, and that was actually part of a famous case also. And you can see lots of other kind of products where a applicant actually filed a design patent, and those are actually protected by the patent law also. I mean, outside US, these are not actually called patent. Outside US, in Europe, they call it industrial design to differentiate it between the utility patent and design patent. But in US, these are called design patents, and you can get 15 years of monopoly for that. On the right-hand side, you can see a couple of things like on the top, you can see the Windows user interface, where when you go through those icons are going to flip and icons are going to move. Those are also a design patent. And below that, you can see the iPhone, one of the iPhone design patent that was part of this Samsung and Apple dispute. Do you have any questions on this slide?
I just want to follow up one. You remember the question we had on composition? We cannot get it, but
Right.
say for a medicine, if I take a composition, it's good for one medicine, and if the quantity is active quantity is varied for another disease, can we get a design patent in that case for the same composition with a different amount of ingredient for two different diseases? Can there be a consider a design patent?
For composition of matter, you are not going to get a design patent, because for design patent, it has to be either a shape, like for example, this Crocs shoes shape, or a surface ornamentation or a surface design. For example, the surface of this tire, you can see on the surface of this tire, it can be shape or it can be a design or something like that. But to answer your question, if the same active ingredient is actually being used for two different
amounts.
Let's say one is using, let's say it has two different active ingredients. For one disease, it's using 2%, and the other one is actually 5%. For a second disease, it's the first compound is let's say 5%, and the second one is, let's say, 10%. So the percentage is clearly different. So let's assume the first one is patented, 2% and 5%. And in that patent, it's disclosed if you use 2% and 5%, it's good for that disease. But you can still file a second patent for the second disease where the percentage is different, showing that it's not obvious from the first patent that, because if the first patent was 2% and 5%, and the second patent you claimed is 3% and 6%, it's arguable, it's very obvious. But if it's a very different percentage, then it's more arguable that it was not obvious. So it's patented.
So I have a question regarding instruments. So let's say we have an instrument and the instrument has an enclosure. Now the enclosure look can be different, while the functionality and machinery inside the box can still be the same. Now, do you have to file a utility patent for the machinery and a design patent for the box? That's question one. Question two is, let's say we come up with a second version or second generation of that instrument, where the functionalities and machineries inside the box changed a little bit, but the look of the machine, meaning the box, has changed a lot. In that case, do you still have to file another utility and another design patent?
When the look of the box, if it does not have anything to do with the functionality, then you can definitely file as a design patent. And it's actually recommended that you file both, because the internal mechanism of the machine, which has a functionality and utility, you file a utility patent for that, and outside kind of look and feel or the shape of the machine, which does not provide any functionality, you can definitely should actually file a design patent for it. So two patents. And if the outside shape of the machine also is dependent on the functionality a bit, because let's say your gears or something has to move in a certain way, for that the enclosure or encasement have to have a certain shape. So that part should also be covered as part of the utility patent application. In that case, outside case should be both in utility patent and as a design patent. So you're covered in both ways. Your design is protected and your functionality is also protected.
So how does the CIP option comes in?
I mean continuation in part?
Yeah.
So in the next machine, when you are actually added some more functionalities in there, and your shape has changed a little bit, So you can actually continue your prior patent application with this continuation in part, saying, okay, I add these other components in there. But if the new invention is a little bit, lot different, so it's actually maybe better to file a separate patent application, because if you're doing a continuation in part, you are actually having some items have a filing date and one date, and some other items that you have added have a filing date of later date. And it kind of makes a little bit of problematic proposition. So rather just file a new patent application. It's a little bit more expensive, but it's clear cut saying that, okay, this new patent application has this filing date, this covers this new invention, and the previous one has a filing date of that, I get that coverage. So it's better in that way.
I have a question, if you allow me.
Sure.
This is Haris Saeed. Hello?
Please go ahead.
Yeah. I have two questions basically. One is when someone filed for the patent and they did not approve it, and maybe it was not properly filed, not properly explained, and later he like to pursue that patent application after several years. Can it be done? And can it be protected? The idea, is it protected already when you file it for the first time? This is one, yeah. Mm-hmm.
Protection only comes when the patent is granted. Unless your patent is issued or granted, you are not getting any protection, because unless you get that legal right of a patent grant, you are not covered for anything. You're not getting any legal protection. So if your initial patent filing had some problem and the patent was abandoned, in that case, if you are the same inventor, if you are filing it within 1 year, you should be able to claim a priority date for that application, saying, because I am the same inventor, so I still can claim the priority to the previously problematic application and file a new application with clean slate that claims the priority to that. You can protect that way. But once that timeline is over and it's abandoned and you were not able to successfully petition that this abandonment be withdrawn, so you can actually prosecute that application, that invention is essentially in the you cannot claim it.
Then legal aspect is here. If a inventor invent something and publish it in as a paper, as you said, technical paper, as you are going through the process of investigating for any other patent applications, that's whether someone has done this type of thing before, how is then that is protected?
Well, if you publish a research paper, from the publication date, you get a 1 year grace period. So United States is one of the countries that gives 1 year. Many other countries gives only 6 months. So the idea is once you publish it, you have about 1 year within which you have to file a patent application. In many other countries, you get only 6 months. So you have to file a patent application. With
so after 1 year, it is gone, right?
1 year is gone in US.
Okay, then my second,
out there where you have to, as soon as you publish, it's gone. So those are very few countries, but there are still some countries like that.
Okay, now my second question was, for example, iPhone, as we were talking about, they have various versions, as it's every couple of years they improve that thing. And every time they improve the version of the iPhones, are they getting another 20 years of their business proprietary right?
Yes, in a way that if they file a new patent application, because their designs change, right? Let's talk about the design aspect of it, because it's easier to understand. So let's say if their design changes and nobody other cell phone manufacturer had the same kind of design, so they could actually get a new design patent. There is a new design, right? New patent. So what Apple does, every time they come up with a new product, even before the product goes out, they actually file patents for it. Because even before the product is disclosed, they are protecting the rights of all those designs, all those ICs. These will be covered by the utility patent, and inside it, all the different technologies, like all the software and everything. That's what the product with utility patent. So they get all those things covered, only then they release their product out there.
Thank you.
So that's what all the companies do out there. Even if they have a new improved product, they always file a patent, then they release the product. They have another product in the pipeline, they keep on improving it. So that's why there is this concept of patent portfolio management. So for example, talking about iPhone, since they're in this cell phone manufacturing business, they have this portfolio of hundreds and thousands of patents. They keep on publishing new patents every year, and they build onto it. So what happens is, let's say one of the technology might be covered a little bit by one patent, but once they have thousands of patents on similar other technologies for the same product, they have a very concrete protection on that. It's kind of harder for somebody else to file a patent and later come forward and say, for this iPhone, I claim infringement because I have the patent that covers iPhone. Because Apple, they already have a very big patent portfolio. So if no other questions, I'll move on to the next slide. So it's about the responses to the patent office rejections and objections. So the objections are simple. They are typically just some corrections or some other minor things that the response later already gonna tell you how to correct those objections. But rejections are harder to overcome because they actually go to the heart of the patent law. So the main three reasons why the rejections happen is 101, which Tauhidul Vai was talking about. 101 rejection means section 101 rejection that says whether it's a process, machine, manufacture, or composition of matter, or the rejection basically says it's not, and it says actually an abstract process, like falls under Ellis, which is a famous Supreme Court case, and based on that, it's actually not patentable. The other, number two, which is actually the most important one, whether it says this patent application is actually anticipated or thought to be obvious based on other prior applications. So anticipation is where all the items, all the components of the patent claim, let's say a patent has 6 steps, all 6 steps are covered by one particular prior art or the prior publication or prior patent. In that case, it will say it's anticipated, so it's not patentable. Anticipation means another patent or publication totally covers this patent. Obviousness is a little bit more broad. So there it says other people have 2 different, 1 or 2 or 3 patents out there, and somebody, a scientist or an engineer who has the knowledge of the same science or art, they can come in and they can combine them or join them together or just replace one part or one process by another process or one part, or in that technology, let's say electrical engineering or computer science or whatever the technology is, there is already available common practices that can be used to actually get that patent or invention based on already technologies that are out there. So this obviousness is the most common type of rejection that happens, and that has to be overcome in many, many cases. Number 3 is not that common. It basically says the description is not enough, or the patent has not been described properly. or the utility is not there, and so forth. So which is not that common. But the most important thing about these objections or rejections are typically there will be a timeline for it. Typically, it's like 3 months, and the response to that objection or rejections have to be filed within that time frame. Otherwise, if it's after 6 months, then patent office is going to say you did not respond to it, so it's over 6 months, the statutory time period within which a response has to be filed. So your patent will be abandoned unless you pay this much money and file a petition to actually revoke that abandonment. Or so that's a bit of a problem. It costs a lot of money in that case. Any questions about this objections or rejections?
Master Bhai, the question on 3, right? When it's not described or disclosed properly, right? So between the written description requirement and the enabling, which one is for you guys difficult? Which one do you guys find difficult to respond to? When the office says that there is no written description versus it's just not enabling, which one is you find more difficult?
The enablement one is a little bit harder. I mean, if it says, okay, it's not described properly, you can just update the description and add some paragraphs in there based on the disclosure already done. And typically it's something that's simple that is missing if it's not described properly. But if it's enabled properly, then it's a much harder thing to do, right? So
I didn't ask you as a policy issue. It's like a stakeholder outreach. So that much we are allowed. Thank you.
Right. Yeah, so any other questions on this slide?
I guess I could ask now. I was going to ask later, which is that for you to write the claim, that term or even that word, does it must be present in the specification, or can you come up with a claim with words that are not in the specification?
I mean, it's always better to have everything described in the specification, because I mean, typically when somebody, the examiner rejects a claim, and then you can go back to you can fall back to the description and say, okay, the description is describing all those things, and you are actually rejecting that claim, so I can actually reword that claim a little bit in a different way based on the specification already there, so that the claim is actually allowed. But if you don't have the description in there, it's much harder to fall back to. It's much harder to kind of reword the claim in a way, because there is no specification to back it up. Because if you have a specification, you're describing it in a very detailed manner, and the claim, you can take that description and write that claim in a number of different ways.
Right.
So one of those ways would be allowed in that case.
Thank you.
So any other questions on slide 6?
Anis Bhai, just one comment. I think you should have a patent attorney to write your claims. That's my suggestion. I mean, it's just based on my knowledge.
I agree.
Not as a policy.
Absolutely.
Okay, so I will move to slide 7. So this is my last one. Essentially, here, this is a workflow for international patent applications. So far, everything that I talked about was US patent applications. So, but under Patent Cooperation Treaty, which is an international treaty under which you can actually file an international patent application. You can, once you have filed a local application, you can see in this timeline 0 when actually you have filed a local application. Means it's a US application or Canadian application or a European application or whatever it is. Within 12 months of that local application, you can file a PCT, meaning Patent Cooperation Treaty application. That will enable you to file that same patent in multiple different countries. So this is a simplified way to do it because one thing is there's an international search authority. It does an international search which can be reused later. And also you get an idea like what's the scope of that patent based on that search report internationally for all the countries. Second, there's an international patent examination that happens that actually does a lot of analysis. Then the other benefit, it gives you a 30-month kind of breathing period or kind of like a time period where you can decide after 30 months, you can see this number 30 at the end of this on the rightmost part of this flowchart, which says when the international patent application is entering the national phase. National phase is when you are actually filing this international applications in all the countries where you actually want to file it. Let's say you file it in month 0 on the leftmost side, you file it in US. Then within month 12, you have filed a PCT application. Then when this number 30 or until month 30 comes in, when you are entering the national phase, you can file it in Europe, you can file it in China, you can file it in Japan, or any other country where you want to file. The caveat is in each of those countries, additional countries you're filing, you still have to pay filing fees for those countries. But in filing fees, in some cases discounted based on some cases international search report and so forth. The other benefit is you have 30 months to figure out whether this invention has any commercial viability or not. Because 30 months later, when you file in Europe or in Japan or in China or any other country where you think there's some commercial viability, it's going to be expensive. And within 3 months, you can get a market perception and decide whether to do it or not. So that gives a lot of benefit in that way. And a lot of the international companies actually utilize that. So all the big names like we were talking about Samsung and Apple, they do it. In many cases, even small companies, when their product is being sold in multiple markets, they also do that. So that was actually my last slide. So now I'll open it up for any questions and answer session.
So on your last slide, can it be, is it possible that you get a same patent awarded domestically but rejected internationally to some countries?
Yes, that's totally possible because, I mean, many countries have different laws, they emphasize different things, but a little bit unlikely, but possible.
So there's a question from Mizan Rahman. Is there any country in the world where PCT does not apply?
Yes, one country I can name is Bangladesh. Bangladesh is not part of PCT. There are only a few countries that are not part of PCT. There are a few in South America. There are a few in Africa, in very remote, not progressive part. And there are one or few countries in Asia. Bangladesh is one, Pakistan is one. I think maybe Myanmar and Iraq might be the other countries. So only a few countries.
So does that mean that they can buy something from overseas and duplicate it without any hesitation?
Not really, because still Bangladesh has a patent system. So you can still file a Bangladesh patent. The only thing is you can't go through this PCT process. So you have to just file in Bangladesh directly.
Okay.
Yeah. Can I make a
comment? Yeah, please go ahead.
On a question, I think this question was, sorry, Rubai, this is your talk, but I'm just adding some information. It's more like a trying to help any stakeholder. Okay. So I think the question was that there was a provisional application filed and I let it go abandoned. Okay. So whether I can go back and file another patent application based on that provisional application, and yeah, you have to do it within 1 year. But see, a provisional patent application doesn't have a claim, so you never say what your invention is. So it's only after filing the normal application you say what your invention is. But there is something that is called a third party filing. So what happens is that let's say you've been pursuing your competitors, see what if they're copying your invention, right? There is a database, you can go search on what is being invented. And if you find something that you have invented in the past, as a third party, you can file it. You can file it with the patent office as well as with the European Patent Office and say that, hey, here is an invention in this application. I have something that relates to this. And that can lead to something called re-exam. Re-exam means to try to invalidate the claim that one of your competitor has, right? Rubaiyat Bhai, you can correct me. But only thing is that that could be a lengthy process. So what you do, if you file a provisional application, then you don't want to spend money to file the US application, then what happens, it only stands as a prior art reference, a piece of knowledge that's available to other people, but it doesn't establish your patent application a claim to an invention. So I guess the intent of the law here is that you tell us what you invented, you describe it, and then we'll give you a patent, we'll protect you. And also the other thing is, if you are late to file the application, you lose the 20 years term, right? I'm just to help you out. But the other part is that if it is a research paper, and then you continuously publish a version within a year or so, there is a chain of things that can prove that you invented the original thing. Then it's okay. You can say that I have pursued this invention. That's called due diligence. And then you can still establish after a certain number of years, say, hey, my original invention is that one. It's linked to this. And am I right, Rubaiyat Bhai, on that? And we're finding it in artificial intelligence art a lot. Back in 80s, a lot of things were invented, and now they are being reinvented again. Okay, so again, what I said is that I did not talk about any patent policy, but I think we have a job to encourage people to share their idea, file their idea. That's what I was doing. Thank you.
Yeah, that's the thing about US Patent Office. They reach out to the inventors and they try to be very helpful to the inventors, giving all the information possible out there. And like what Tauhid Bhai, you said about the ex parte examination, or there's supplemental information that can be filed. So it makes it easier for the inventor to also weed out any patent application that's actually not a good application. That's already been invented, already been out there, already been published. Why should somebody actually, as a public policy, why should they be getting a monopoly on that when it's actually invented or published out there? So that totally makes sense as a public policy.
Any other question, please?
I raised hand. I have one question as a business questions to the attorney, as you are handling this thing. For example, if someone is interested to file an application and they reached out to you and they discuss the thing, do you usually go through everything and say whether it is patentable or not, or you just take the case and submit the patent application anyway? This is a practice. I'm not talking about you. I'm talking about usual practice of the lawyers, patent examining lawyers.
Right. Yeah. I mean, every lawyer would try to make sure that they are not making their clients kind of file for something and pay the fees for nothing, right? Because I mean, there might be attorneys out there who do that, but any good attorney won't do that. So typical process is you talk to the client, initially get an idea based on whether it's a process, manufacturer, or a machine, whether it's not abstract or not. You get a kind of sense whether it's really patentable or not. If it is, or if it is borderline, you still try, you do the patent search, you try to figure out whether it can be argued otherwise, but you still tell the client, look, it's borderline, there's a 50-50 chance. Do you want to spend your money and actually take that chance? Because you can get it, you might not get it, right? So in other cases, when you know it's a concrete case, then you tell the client, okay, now let's do a patent search, move on to the next step, and spend a little bit more money to figure out whether it's patentable or not, because it could be obvious, it could be anticipated based on the prior art. But if it's from the initial consultation, it's clear, it's not patentable, it's not a patentable idea, then you'd discourage that client from filing anything.
Thank you. Thank you.
So here is a question from Qazi Zaman. Two questions. What is your opinion of the Bangladesh patent system today? And number two, what is the average cost to file and get a patent?
About Bangladesh's patent system, I mean, Bangladesh's legals, I mean, one thing I was already talking about, it's not part of PCT, right? One of the most important thing is Bangladesh to join the PCT, because there will be rarely anybody who is going to be filing a patent application in Bangladesh just for Bangladesh's sake. At best, what they are going to do, they are going to be filing a PCT application. And as part of that process, one of the countries they're going to file it is in Bangladesh. So Bangladesh is missing out on that. And one of the main reasons is many of the laws in Bangladesh has been dating back to British era for about 80 years ago. So that hasn't been updated, which should be updated. I mean, that not just for patent law, for any other general law, legal fields in Bangladesh. The other question, what you asked, what is the general cost? I don't know about Bangladesh. I can tell you about in US. That depends on the entity. So if you are a private person, you have not more than 4 patents, and your gross annual income is less than 6 times of the annual household income or average income, which is, I think, around $200,000. Then you fall in a what is called micro entity, which is a new category that's been created, which it gives you 75% discount. Next group is called small entity, where any individual or any small businesses or nonprofits, universities, they fall into that category. There you get about 50% discount. And if you're not a small corporation, you're just a big corporation, then you fall under undiscounted category, where you have to pay 100% of the fees. Those 100% of the fees could be quite a bit. I mean, depends on a lot of the other aspect, how many claims. Typically, you get 3 independent claims, and total, based on all the dependent claims, up to 20 claims within the basic filing fee. If you go over that per independent claim, you have to pay additional fee. And also, if there's a multiple dependent claim, which typically nobody files because it makes things complex, and you also have to pay additional fee. So fee calculation actually depends on the case-by-case basis. But US Patent Office has a very good fee calculation table that can also be used.
So Rubaiyat bhai, Zaman again. So what I'm trying to figure out is, like, you know, in US, if you're doing a design patent versus a process patent, you know, what's the average cost? Is it like, you know, because sometimes, you know, as, how should I say, VC folks, or in the VC industry, we're trying to, or angel investment, we're trying to guide some of the startup companies to, you know, go and file it. And from that perspective, you know, when we have to do the cash flow planning and whatnot, budgeting wise, what is it? Is it $10,000, $20,000? Where does it fall in average? I mean,
for general, I think it's around 10,000 plus minus, including all the fees, patronage fees and everything. But it still depends. If it's a very simple patent, it could be cheaper. It will be a lot cheaper. If it's a very complex patent, it could be a lot more. Okay. So that includes filing fees, drawings fees, patent search fees, all those fees together. And then there's office action fees. So when attorneys have to respond to the patent office actions and so forth. So yes, 10,000 is, I think, ballpark, roughly average range in the US.
So follow-up question, Rubaiyat, to Zaman's question. Follow-up is, you mentioned this 75% discount, micro entity, 50% discount, small entity. That's the PTO fee, not the lawyer fee, right?
Right.
That's the U.S. Patent Office.
Patent Office.
Correct. Correct.
And what is the full fee? What is the full fee?
It depends on different attorneys. There are attorneys who would be charging a little bit lesser fee. There'll be attorneys that will be charging more fee. So attorney fees vary a lot based on small firm attorneys are going to charge less because they have less overhead. Big law firm attorneys, they're going to charge more because they have more overhead. And because of the big law firm, they have bigger clients who are actually willing to pay more. So it's based on all those kind of criteria and everything.
But the PTO fee is not dependent on lawyer issue, it's their fee. So what's the full fee for the PTO office fee? The application fee.
As I mentioned, like it depends, but typically for a patent, typical utility patent with everything like examination fee, filing fee, search fee, all those things together, what I was talking about generally it's 20 claims within which there are 3 independent claims, roughly around, I think for a small entity, roughly close to about $2,000.
That's good, thank you.
All right, any other questions, please?
So I have one piece of information to share with everybody, since some of you are interested to file a patent. The people who examine the real patent on the merits, they never know about the fees. It's the chief financial officer's office that does it. So just to let you know that the examining a patent on the merits is totally separate from how much it costs. But on the other hand, also there are some in the whole patent prosecution process, there are some steps where it's the office is going to be a lot more friendly, in the sense when an application is finally rejected, there are options when you can have additional interviews with the office, and a lot of time we are like, this information is okay to share because it's not a policy issue. If I receive a call, I have to respond in 24 hours, regardless of whether it is weekend or not. I must call back and leave a message there. And these are all being tracked within the system. So if you'll find out that there are ways, and most of the patent attorneys are the very friendly people in general. 99.5% of them. They are very helpful.
So if there's no question, I'll ask another question for Rubaiyat Bhai.
Sure.
So, over the last 25 some years, we see a certain pattern in the developing nations, especially, US has been, I think, leading in the intangible side of the investments, meaning rather than the tangible investment, intangible investment, especially in the IP side, has been significantly growing over the last 25 years or so. And Europe actually has followed up US, I would say, over the last 20 years. Is there a, should developing countries like Bangladesh focus on this? And what do you think the value quotient of focusing on the intangible is or could be in growing the GDP over the next 10 years? You know what I'm saying?
Right. It's very important because I think if you look at China in last 5 years or 10 years, if you look at their number of patent filing, it has been going up like astronomically. It's been like exponential growth. They not only file in their own country. I've spoken with a lot of my clients who actually do a production facility in China, and they mentioned that there the government actually gives some sort of benefit and kind of incentive to file patents over there. So you actually file patents, the government is going to give you some money or tax break and other kind of benefits. So that's actually increasing a lot of patent filing in China. That's increasing a lot of patent filing from Chinese companies in US and Europe in other countries. And one of in PCT filing, their PCT filing has grown a lot. all these are actually creating a knowledge-based economy in China. So that's where China is growing. Same thing if a developing country like Bangladesh, they do it, then that's also going to be very helpful. For example, right now, a lot of the investors or manufacturers don't want to manufacture in Bangladesh because they know there is not much protection from the intellectual property. The intellectual property law is kind of outdated, not part of PCT and so forth, right? So if we have that kind of infrastructure, kind of legal infrastructure, where we are not only have a better or new or modified, advanced, updated law that actually protects these intangible properties like intellectual properties, but also there is a kind of like culture, like where in China, government is giving incentives. Intangible properties are promoted and intellectual property are being promoted, then that will create a very good investment environment in Bangladesh. And also it'll be good for the manufacturers, local manufacturers. They can actually compete in the global level in that case.
Shaq, go ahead. Shaq has a question.
Yeah, I don't know if the question has already been answered because I was briefly out for a few minutes. Good presentation. My question is more relevant to the company that you have and the service you provide rather than what patent does. Do you provide any pre-examination if somebody has an idea and they are willing to file a patent, but they're not so sure? A lot of time there are so many, like probably you have services where you can look at even pre-approved patents or provisional patents that has been approved, unlike the masses who may not have. Do you provide those kind of services?
Yes, I mean, I think you got into two parts where it's actually an idea where you want to patent it or not. In those cases, we provide some initial free consultation. So anytime, feel free to call us or go to our website, send an email. We provide initial free consultation to figure out whether it's patentable, should we file a patent or not. Then if you have a provisional patent application, then you can also bring it to us. We can actually provide that initial free consultation and see whether it makes sense to file a non-provisional patent based on that, or if there is any issues with that application. Because there are so many companies out there who actually claim they're gonna help you file a provisional patent application. They are not actually patent attorneys. They're just some firms out there for a very nominal fee. They're gonna get you a patent application, provisional patent application, but the quality of that might be a little bit questionable.
So there's one more question from Hafizur Rahman Bhai. Question is, how the USA patent process differs from developing countries?
I am assuming the question relates to like US versus Bangladesh, right? I'm not very familiar with the patent process in Bangladesh, but internationally, even if you say developing countries from Asia or in Europe or in South America, even many African countries who are part of PCT, what those countries have done, they have tried to align their law with PCT rules and regulations articles, basically making sure they have these, many of the processes kind of align with PCT other countries. So it's more streamlined. So internationally, even if it doesn't matter whether it's a developed country or developing countries, they are all coming close and they are kind of streamlining their processes. Even US, like in 2013, when America Invents Act, the new patent law act that came into effect, even with that, US tried to come close to all other countries in the world. So kind of align itself to other countries in the world. So that's been happening, not just for developing countries, but for developed countries too.
If I may add something to the examination process for answering to Hafiz Bhai's question, I think if I compare US patent prosecution system on the patent office side, if I compare it with the one in Europe, the I think the US Patent Office has some criteria that are a little more stricter for the examiners. For instance, there are two standards there. One is correctness of the report that we provide when somebody files for a patent. It's not only correctness, but on top of that, we have to clearly say, which is called clarity. So in other words, is the evidence that we are providing, we have to pinpoint exactly where that particular claim element is present in that piece of evidence, right? Provided by, I think you see that. And what has happened during the last 3-4 years, and I can share it with people, is that the standard, see, normal US standards is preponderance of evidence, right? So you weigh evidence, but in this case, the burden on us has increased a lot, where if an examiner writes a report and then the stakeholder is saying, I do not see it there, they can go up the chain and ask someone else, say, can you clarify that? And we are encouraged to do that. So again, I think the US has the most detailed process, and US has the most enforced patent system. So everybody wants to file a patent to get a patent here. And so in turn, we have to do a very detailed job.
Right.
Yeah, that's been very helpful because, I mean, I know it's a little bit more burdensome for the examiners, but this patent office internal regulations that actually encourage the patent examiner to outline all the reasons as detailed as possible. There is this in the manual of patent examiners manual, patent examiner procedure, MPP, you have all these detailed procedures, which actually says you have to reply in this way, and you have to reply in this much detailed way, which is actually very helpful for anybody who is prosecuting the patent from outside, like an attorney or inventor, because that gives all the information that is needed to file and reply or response. So, which is very good for the whole process. Might be, I'm sure it's very onerous for the examiners, like Tauhid Bhai yourself, but it's very helpful for the overall process.
So I'll ask another question, Rubaiyat Bhai. You know, as a lawyer and an engineer, how do you think the role of open source technologies has come about and impacting the intangible or the patent areas? You know.
Yeah, I mean, open source has been very influential in last 20, mainly last 10 years. And that open source really impacted a lot in the computer science area. I mean, now if you look at it, there used to be the days when you had to have HPUX or AIX or any kind of Unix environment or servers. Now, there is nobody out there, even HP or IBM or all of those companies, they are actually selling Linux or any kind of open source Unix platform. Same way, like if you look at Oracle, which has been like a big enterprise software powerhouse, even they are now selling lots of different open source enterprise software. So that's been very encouraging, and in a practical or kind of like an application space. And from the legal space, the licensing has also been evolving. I mean, in the old days when you used to look at Linux or any kind of open source, you'd be GNU private license and those kind of license, then came MIT license. Now, those licensing are also evolving, and those licensing are becoming more open and less restrictive, so that this whole open source platform can actually grow. And a lot of companies, now the open source model or a lot of the software model has been is you write an open source, share it to all the people, but since you are the contributor to that open source, you have a very good consulting expertise, and you can actually sell that consulting expertise to different companies out there. So it does two things. It does produces revenue for the company, and on the other hand, it is also encouraging that open source software growth. And a lot of the software, even I don't know any company out there who does not use open source anymore. even US government uses it. So that's been very encouraging recently. And it's also from the legal perspective, it's been growing.
So if I may focus a little bit more in this area. So do you think GPLs and MIT open licensing, these actually facilitate the opportunity for patenting?
I mean, software patenting, as I was saying, like it's a little bit harder. Most of the software, they try to protect it under copyright umbrella, and copyright gets affixed as soon as you write it, even though USPTO or actually US government, federal government encourages you to actually register it. But it's still, most of the software gets protected under that copyright umbrella. From the patent perspective, that licensing, I don't think has impacted that much, because if anybody has that kind of technology, they typically want to patent it before they open source it. Open source has been in the cases where technology has been out there, technology is very solid, technology is open, nobody can claim I have patent, I could have filed patent, I had other rights, and et cetera, et cetera. So it kind of tries to divert away from that.
Okay. Also, as I think I'll go to a different tangent. As you're also in the investment, area, especially in the investment banking side, would you be able to say, like, because there are a lot of engineers over here, why patents are important for technology firms, and how does it impact the valuation? So if a company A, has focuses on investing in developing patents versus company B who does not, and if they're equally the same, what are the, how does it impact the valuation multiples when patents are there? Can you give us some industry ideas?
Yeah, one of the biggest impacted industries, pharmaceutical industries. There, everything is patent. Yeah, a startup company essentially starts with lots of patented ideas. Those could become a blockbuster drug, or could be a flop after FDA approval process, phase 1, phase 2, whatever phases, right? So those companies, mainly valuation comes from the patent, and valuation are kind of estimated valuation of those patents, whether and applicability of those patents. In other industries, like electrical industries, which files a lot of patents, like if you look at Samsung, Apple, or Intel, or NVIDIA, those kind of industries, they file tons of patents, more patents than pharmaceutical industries. And they are also, the technology is valued by that, but the problem is they don't have, it's kind of harder to guess or estimate the valuation of those patents, because a company like Samsung or Apple, they have hundreds of thousands of patents over the course of effectiveness of 20 years, right? So more or less what investors estimate in those cases is, what are the products out there, what are the products in the pipeline? Because each of those products, like a Galaxy phone, has thousands of patents. You can't really estimate that. Same thing with many other industries too, like if you look at heavy industry, or airlines like Boeing or Airbus, and those kind of industries too. But in the pharmaceutical industries, healthcare, like medical devices industries, definitely yes.
If no more question, maybe if no more questions, maybe we can adjourn here. But if anyone has any more question, please feel free. We can have 5 more minutes.
Thank you, Rubaiyat bhai, and we'll touch base, inshallah, Arif bhai.
Yeah, thank you.
Okay.
Thank you very much.
Well, we can't thank enough Rubaiyat for taking his valuable time, because attorneys always bill by the hour, right? So,
No, I don't bill by the hour. I typically bill a fixed rate, so that's
good for us then.
And my initial half an hour and 1 hour is always free. So no problem.
Okay, wonderful. Good to know that. But Rubaiyat must be an exception in the whole suite of attorneys, that they are really good at billing you. But anyway, we can't thank him enough for his time and valuable information. I learned a lot from Rubaiyat as well. And if anyone has any more questions, please feel free to email, and I'm sure he will get back to you by email as well.
Yes,
So with that, shall we adjourn? Thank you
Thank
all.
you. Thank you, Anis bhai.
Thank you.
Absolutely.
Thank you.
Until next time.
Thank you for promoting patents. That's what we.
Thank you
bread
for
and
honoring the
butter. Thank you.
request. So Zubair bhai came to me and
Sure. Sure.
wanted to talk about that. He wants to talk to ABA about
Bring
that.
more
I was-
recommendations.
I was listening. I was busy in doing weekend some work.
Yeah,
Okay.
Jahangir, please feel free to bring more recommendations. Rubaiyat was a very good choice.
All right. Could be some more presentation could be put on ABA website so that
Yeah,
we can
it
learn
will be.
some references as well.
Okay. Thank
Okay.
you all.
Thank
Khuda
you.
Hafiz.
Thank you
Bye
very
bye.
much. Thanks.
Bye bye.